Good morning and welcome to today's webinar, Meet Your Cleveland Local Lawyers. My name is Amy Clum Holbrook and I'll be the moderator of today's session. I'm a partner at the firm and I've been here about 20 years. I'm also lucky enough to manage the Cleveland local office. Before we get started, we have a couple housekeeping items to address. First, this is an interactive session. So as you have questions, feel free to submit them through the question button on the control panel. We'll do our best to answer your questions as we move along through the webinar. Keep in mind as well that this session is being recorded. At the end of the session, you'll get an email with a link to the recording for your records. And finally, there'll be a short survey at the end of the event. So please take that survey and share your feedback. We appreciate hearing what you have to say and how we can improve in the future. And the last thing I'm responsible for in this introduction is giving you the legal disclosure. So this seminar presentation will provide information concerning potential legal issues, concepts, factual situations, and information. This seminar and the material provided is not a substitute for legal advice from a qualified attorney on any matter, including similar or exact factual scenarios that may be provided or proposed. This presentation is not created or designed to address unique facts or circumstances that may arise in any specific instance, and you should not and are not authorized to rely on the content as a source of legal advice. The presenters will advise you to seek competent legal advice on the topics presented. This seminar or seminar materials do not create an attorney-client relationship between you and the law firm of Weltman, Weinberg, and Reis. That's enough from me. We're going to move on to our first presenter, who's Scott Weltman.
Hi, good morning, everybody. My name is Scott Weltman, and I am an attorney and a shareholder with the firm. I've been with the firm about a little more than 30 years, and my practice area is, general collection litigation, representing banks and businesses, mostly in business type recovery matters, but certainly other related matters as well. I also happen to manage the firm's probate recovery practice, and we've done webinars on that in a different forum. So I'm happy to speak to you today. I've been given 5 minutes. What I have to cover would take me 5 days, but we're going to condense it all down and give you a real quick overview of what to be expected in the process of pursuing a lawsuit and client involvement. So the most important thing for everybody to know is that a client's involvement is critical to the lawsuit process, to the collection lawsuit process. So obviously every case is different based on the facts, but I would tell you that certainly at the beginning, we must engage with you as the client in understanding what the case is about. And then as the process goes forward, I'll certainly lay out a few of the expectations that we have for you. So obviously when you have a matter that you need to retain our law firm for, the most important thing to convey to us as your attorneys is what is the factual background. Why are you owed the money that you're owed? Why are you hiring our firm? And it can be very simple. Sometimes a client will send us an email and we have all the information we need. But other times they may be very fact specific. I happen to like to speak to my clients. I'd like to have a little conversation, some dialogue, to have a full understanding of just what is involved, and we can talk about the path that you're going to go through. And obviously, we'll need documentation. So there's different viewpoints on how much documentation to provide. There's the very little point of view, and there's the everything you got point of view, and then there's the Goldilocks just right point of view. And obviously, what's important to me is I've got to have the documentation to be able to see it and convey it to the court on the beginning of our lawsuit on why you're owed money. So for some of you, you have a promissory note and there's a default, and you're going to provide us the note and maybe a payment history, and it's that straightforward. Other cases we get involved in are very fact specific. There's a long background, and we need documentation that provide us that information. What I can tell you is that when we file the lawsuit, we're going to attach the right documents as exhibits, and so those have to be reviewed. In certain cases, we'll have to redact them for you, but there may be a lot more documentation. There may be a lot more documentation that goes through the case. Whether you want to get that all to us up front or not, that's probably a matter of personal preference between the client and the specific attorney. What we need to know is that everything that you have will be made available in the course of the litigation. So I don't need to be the repository for every single document in a lot of cases, but I do need to know that when we reach the right time in the case, you'll have it available. And many of our cases are very document specific, document intensive. We'll use them along the way. Just the most critical thing is being available to talk to us as the attorney, being very responsive. That's what's necessary. And the last topic that I really want to cover is what can you as the client expect your involvement to be in the process? And it probably breaks down into a couple different categories. First of all, when we file a lawsuit, we're going to send you an affidavit right away. We'd like to get an affidavit from you as the client if and when we need to file a motion for default judgment, if there's no response. And so if that occurs, we'll get that to you. We ask you to send that back to us right away. And then as the case goes on, there may be other affidavits. If we're going to file a motion for summary judgment, that'll be a more involved affidavit. Probably the most critical involvement that you have as a client is being involved in the discovery process. So when we have an opponent and the case is being litigated, we may get requests from the other side for discovery. We need your involvement actively to review that information and to work with us to craft those answers. You may need to have your deposition taken. Obviously, if that's going to happen, we'll sit with you, we'll prepare you for that deposition, but you'll be the most important witness in the case because you're gonna tell the court what our case is about. And then the most important part at the very end, we maybe get called to a mediation, and you may need to attend a mediation with us. You may have to go to court for a final pretrial. And ultimately, of course, if the case doesn't get resolved, doesn't get settled, we don't get it resolved in dispositive motion, you're going to have to be our witness. You're going to have to come to court with us, sit at court, take the stand, get under oath, and have testimony, all of which we will prepare you for. And every single piece of the case, as far as the client's concerned, is critical, right? The lawyers, we're only as good as the clients are. Our clients are excellent, but we certainly need your involvement. And that is my very quick summary of the lawsuit process in my 5 minutes. Thank you very much.
Scott, I heard you mention client appearances for like depositions or mediations. What do you think the estimate is in your practice of how often that occurs, like percentage of cases where clients actually have to appear? Because you know they get nervous and about coming to court. So
yeah, thanks, Amy. I would say that's probably, it depends on the case, but on the simpler cases, if you will, more straightforward, very infrequently, probably 10% of the cases. And if we get involved in more complex litigation, I know what others are going to speak about those kind of cases, those percentages are going to increase. So, but we would also give you ample advance notice of that occurring. We get those schedules early, we get those on your calendars, but the ones that go to trial are, we will go to trial probably in 5% of our cases or less.
Thank you, Scott. The next one we're going to move on to is Dan Friedlander, who's going to talk a little bit about what happens in a counterclaim case and what clients can expect.
Thank you, Amy. Good morning. My name is Dan Friedlander. I'm a senior attorney and I've been practicing law for about 39 years. After law school, I was the senior law clerk for Justice Ralph Locher on the Ohio Supreme Court. I went on to a large Cleveland law firm where I handled various types of business and insurance defense litigation. I then went in-house with a large bank and bank holding company where I dealt with litigation issues, both managing them and litigating them. I started at Weltman about 12 years ago and typically work on defensive litigation such as counterclaim defense, contested issues like responding to mortgage foreclosure counterclaims, dealing with discovery issues, complex motion practice, and appellate litigation. I've been asked to briefly discuss the initial actions to take when you receive a counterclaim. We all know or should know that the legal system is rarely about justice or fairness. It's about resolving disputes. We sometimes win cases we should lose, and we lose cases we should win. But that said, in the world of collection litigation, we win far more cases than we lose. So there's an inclination to assume that anytime you receive a counterclaim, it is a frivolous ploy to waste your time, harass you in order to leverage a more favorable settlement or even a mutual walkaway. While that may be true, it does not mean that you can't lose or you should not take the case seriously regardless of your preliminary assumptions about the merits of the claims. The first time you'll hear of a counterclaim is usually from your existing counsel. so I can dispense with the first step of when you receive a legal complaint, which is to make sure you record the date of service and contact your attorney. Presuming your attorney is in the loop, the next step is, first, check to make sure you put in place a litigation hold. Because most litigation clients in the collection world don't focus on defense and being sued, it's essential to follow the protocols when you are sued. I assume most of you have standard protocols you follow when you receive a lawsuit, and if you don't, we'd be happy to discuss that with you. One protocol element when you receive a lawsuit of any kind, including a counterclaim, should be a litigation hold. To avoid possible court sanctions, you need to hold all information that relates to the matters asserted in the counterclaim. If you have documents or electronic data retention policies to regularly delete information, files, or emails, you need to temporarily suspend the policy if it impacts the information and data you need to hold. If you can lock the retention date so you don't eliminate the litigation hold information, you need to do so. If you have to temporarily suspend the data system so an automatic deletion feature does not destroy relevant data or communications like emails, contact your IT department to do that immediately, and you can then discuss further steps with your attorney. It's important that you do not destroy any potentially relevant information relating to a matter in litigation. If you do, there can be serious and unpleasant consequences to defending or prosecuting your case, including in court-imposed sanctions and even dismissal of your claims. The next issue is insurance. You may not think a counterclaim is potentially covered by insurance, but often commercial or business law claims like breach of contract or tortious interference with business relations, which might not otherwise be covered, can include allegations for physical harm in the form of an emotional distress claim. You may also have errors and omissions coverage or specialized coverages for statutory violations that may be covered. And if you do not report the claim in a timely manner, the insurer is not likely to cover an adverse outcome or potentially pay your attorney's fees under a reservation of rights, which can often be the most expensive aspect of litigation. It's always a good idea to run the counterclaim by someone with appropriate coverage expertise, whether that person is your broker or agent, or you have an in-house department that deals with risk management issues. Finally, is the risk assessment and cost-benefit analysis phase. After you've locked down the emails and sent a note to your insurance agent, it is time to take a close, subjective look at the counterclaim and check the facts as best you can to see if there are any problems. Your attorney can help guide you through this process, but you will need the facts before jumping to any conclusions. You will need to determine if there is any arguable merit to the counterclaim, what steps will need to be taken for defense, and the potential costs of defense. At that point, you can make a reasonable business decision on how best to proceed. Every case has different considerations, but it's essential not to make assumptions before you can figure out whether a claim has merit or should be settled or dismissed. In any litigation, it is essential to understand what you are trying to achieve and to figure out the most efficient way of getting there. Because of the uncertainties of the litigation process, what you believe the merits of a claim may not be what a court thinks the merits are. It is therefore critically important to look at a counterclaim objectively to properly weigh the business risks. As attorneys, it's our job to help you make that decision in a practical and cost-effective way to help achieve the best possible outcomes. Thank you.
Dan, you mentioned the litigation hold. What should a client do if they discover they've accidentally disposed of something that maybe should have been held in the first place?
If they've accidentally disposed of something, they really need to get to the bottom of exactly how the accident occurred. If the firm or business has protocols and whatever occurred happened contrary to those protocols, it's important to figure out why the mistake was made. So if the issue comes up at some point, you can go back to a court and say, hey, this is what happened, and this is why we believe it wasn't intentional in any way, shape, or form. It was simply an error on our part.
Thank you, Dan. Our next speaker will be Amanda Yurechko, who's going to talk about what happens when an appeal gets filed.
Hi, I'm Amanda Yurechko. I'm a partner with Weltman. I've been here over 20 years. In that 20 years, I've gotten to handle a wide variety of matters, from your typical, what you think of as a traditional collection account, to property damage, professional fees like attorney's fees or accountant's fees. And, even last year I was handling a dispute between neighbors where one thought one poisoned the other's tree. So I've handled a wide variety of cases here. My topic today is appeals. I'm going to give you some ideas of things to think about and talk to your attorney about. If you have an appeal pending or you have specific facts that you want me to look at, that you feel free to call me or give me a shout or an email after to look at that. But an appeal happens when you have a judgment, you've gone one way or the other, you've either won or you've lost, and it's important in both cases. In the worst case scenario, when you've lost, your first inclination, and even as attorneys, our first inclination is, oh, that's wrong, I'm going to appeal. But you have to be able to step back and look at the case critically and figure out, you know, the law could have been on your side, but you just had bad facts in this case, or what went wrong in this case. And sometimes when you have a case that has bad facts, you want to be careful not to make bad law. I do a lot of work for utility companies in the excavation arena, and the law is pretty fairly set. There's a statute that sets what everybody's responsibility is. But there is a case out there that we confront all the time that just had bad facts. And it didn't come down in a good way. And we have to, you know, in a lot of cases, we're trying to distinguish our case from that case, and we have to confront that case a lot. So the last thing you want to do is make bad law in a really settled area of that you're pursuing. So on the other hand, you know, you may want to pursue it if you know the judge just applied the law wrong. There you have plenty of examples on your side. So the standard of review, if you won on a motion for summary judgment or won or lost on a motion for summary judgment, the standard of review is de novo, which means that the Court of Appeals is going to look at it fresh. They're going to look at the facts, they're going to look at how the law was applied, and they're going to interpret it fresh. So it gives you a whole second look at everything in the case. However, if you went to trial, the findings of fact by the judge or the jury are reviewed under an abuse of discretion standard, which is much higher. You have to show that the finder of fact abused their discretion when they were looking at the facts. But you still look at the law under that same de novo standard. So it's important to know how your case came down on your side or you lost, to know whether an appeal is good for you or not. When you win, the question is, do we start collection right away? And in most cases, the answer is yes. In most cases where the other side is represented by counsel, they're telling them whether it's a good case to appeal or not, and you're not going to push somebody into appealing just because you started execution. There are some times when we've held up because it's a pro se defendant, someone's representing themselves, and you don't want to entice them into filing an appeal that they wouldn't ordinarily file. But the good thing about starting collection right away is that you can entice the other side to ask for a stay. And if they ask for a stay, Ohio Civil Rule 62 says that the stay is only applicable when they post an adequate bond. So you can get them to ask for the stay and post a bond that sits there while the appeal is pending. When you win the appeal, you can apply to get that money from the bond. The idea is that they should post a bond that's enough to cover the principal and the interest that runs during the appeal. But there are plenty of cases where the courts are deciding how much is an adequate bond. There's one case where the Akron Beacon Journal didn't have to post a bond at all because they had such strong ties to the community, and the court found that there wasn't any risk of losing anything by letting the appeal pen. But you're in a best position if you can get that bond posted. There are rare times when we've hit we've done a bank attachment and been able to hit the full balance, and they don't ask for a stay, and we get the money, and then you can satisfy your judgment, and the appeal goes away. Again, there's a lot of things to think about when you're making the decision whether or not to appeal a case or how to move forward, knowing the other side may appeal. And so, feel free to reach out and talk to me about those issues.
Amanda, we have a couple questions. So what's the average length of time the appeals process takes?
On average, I would say 6 to 12 months. It's going to be affected by what court you're in, whether the court pushes you towards a mediation. A lot of courts are pushing a mediation before any of the briefing gets done. Whether the other side takes extensions, whether you need an extension, those things can all affect the timing.
And another question is, what happens at an appellate mediation that didn't happen in state court?
The appellate mediator I've found is well versed in the law and will take a good look and understand what the issues are in the case, and maybe have a better idea of how the Court of Appeals, which way the law is trending, and take all those things into effect when they're attempting to mediate it. They may push one side harder than the other because they could see how the case is going to come down. And so you get a second fresh look at your case and how it may be ruled on.
And one last one. What happens at oral argument on an appeals case? And do clients have to be there?
No, clients don't have to be there. They could be there if they want. It's really, you get a certain amount of time to stand up and argue your case, and you're really just arguing the law. You don't want to review the case and all the facts for the court because they've already read your brief. You've already briefed it for them. You want to review the law with them, make sure you get your points in, and answer any questions that the judges may have.
Thanks, Amanda. Our next speaker is going to be Don Mausar, who's going to talk a little bit about what happens when you have an account or a file that looks uncollectible or it's not performing the way you want, and what are some options you have. I think you're on mute, Don.
Okay, take two. Good morning, everybody. My name is Donald Mausar, and I'm an attorney and shareholder at the firm, and I'm pleased to talk to you today about collecting judgments and what do you do when you're digging deeper, or what do you do with a non-performing judgment. I'd like to invite you all to contact me if you have questions following today's program. You can reach me at the firm, and if I'm not by way of email or by phone, then you can find me at Headlands Beach on the sand or at Menor Lagoons out of the water. So I hope you have a safe spring and a happy summer as well. When you're collecting a judgment, they range, right? It could be a routine collection where you may have somebody who is a normal worker that works a regular job, draws a paycheck, and you could do wage garnishments or bank attachments, or you may have a complex judgment, which is going to take some time and effort to figure out the appropriate strategy in order to enforce that judgment. A lot of judgment collection work is based on process and strategy. There are certain remedies in Ohio which are very process driven. For example, wage attachment requires certain notices and forms, as does an attachment of other than personal earnings. That may all be part of your strategy. It is always important to act timely when you're trying to enforce a judgment. The water going down the river could be the assets at the same time. So you want to act timely, and you want to make sure that you enforce your rights as quickly as possible. One of the things you may want to consider while you're reviewing existing judgments that you have in your portfolio is whether or not your judgment is dormant or can it still be enforced. A dormant judgment is a good judgment in Ohio, but after 5 years of inactivity, it will go dormant and it will need to be revived. If you have to revive your judgment, it'll require service on the judgment defendant as well. When you're looking at judgments, you should always consider, what do you know about the person, or what did you know at the time that the credit was extended or the judgment was rendered? Do they have real estate, or are you familiar with cars or property or things that they may have in their name or did at one time? Some of your legal remedies include property liens against real estate, in-court asset exams, post-judgment discovery, attachments of personal property, such in the form of levies and things like that. You have a lot of tools in the judgment collection toolbox that you can use if it's appropriate at the time, and if your judgment is collectible. You should always consider, when I'm talking to my clients, we always look at the balance and how much the core costs are going to be, and where's that special margin? Like where does it make sense to invest more money versus when it doesn't make sense to invest that money from a business standpoint. You can enforce a judgment that's from out of state in Ohio. You would have to domesticate it to Ohio through a certain process. Remember, process. you'll have to do that, but we can enforce out-of-state judgments. We could assist you with that. And those are sort of the high water marks when it comes to collecting judgments. If you have a complex judgment, high balance, difficult defendant, fraud, theft, embezzlement, anything like that, you're going to use the same tools, but in a different manner. You're going to probably develop a strategy before you start to use those different tools. You're going to develop a profile of the person and what they may or may not have, and start to pick your spots. And the key to collecting a judgment in that regard can be at times pressure, right? Building the pressure like a pot of water boiling until you either fully collect the judgment or bring them to the table to talk about a resolution that may be acceptable to all the parties that are involved. I know I'm going to be coming up on my time in a few minutes, but I wanted to talk to you about what do you do with a non-performing judgment? Well, first thing you need to do is recognize, is it uncollectible? You know, your judgment is as collectible as the person or the entity. And for example, if the person is deceased, your judgment may have, you know, other than probate, your judgment may not be collectible. Or if the company is out of business, if they don't have assets that are left, it just may be uncollectible. You should always, when you're considering if your judgment is non-performing and uncollectible, solidify your position in terms of your records, right? Keep track of what you knew when you knew it, document everything that you knew, follow up every lead before you consider it to be uncollectible, and should always keep your eyes and ears open to see what leads you may come across. I don't have anything more to add for you today, just an invitation to reach out to me personally and let me help you with your collection needs and recover the revenue which you've lost that's unperforming. Thank you, everybody.
We have a couple more questions down for you. How long is a judgment good for in Ohio?
Thank you. Statutorily, the law has changed over time. You can generally consider it at 10 years, but it would depend on when the judgment was rendered because of some statutory changes. And recall, I mentioned to you the concept of dormancy. If you have a judgment, it will go dormant in 5 years if you do not do any attachments. And that could be an in-court asset exam, a bank attachment, an attachment of other than personal earnings, a wage attachments. Those will all keep your judgment alive. Otherwise, it will go dormant.
And what does dormant really mean, and how do you fix it?
Thank you. Dormant means your judgment is still enforceable, but it's in timeout. Okay, we all may know what timeout means. It means your judgment's in timeout until you can revive it. And that's going through a process that's similar to a lawsuit in terms of you have to get service through the clerk's office on a motion to revive judgment. The only defenses are payment or time barred because the judgment is fully expired versus dormant.
You also mentioned levies. We had a question come in about what's a levy and what's the procedure for getting one?
Thank you. A levy is an effort by a judgment creditor to seize personal property. They are done through the local courts wherever the property may be situated or through the court where the judgment was rendered. You can levy on anything, any type of personal property. It could be cows and pigs. It could be a dog. It could be wildlife. It could be cars, motorcycles, farming equipment. Anything that's not real estate is considered personal property, of which can be levied upon through the appropriate process, through the appropriate sheriff's office, and following the procedure that follows.
Is there anything a client should be leery of if they're asking for a levy?
A cost and expense. For example, if you levy on farm animals, you will have cost and expense to house them. If you levy on perishables, they have to be liquidated promptly so that they don't expire or perish while in your possession. You should, cost is really the most important thing to be concerned with. Other than that, there isn't really much to fear by way of a levy.
And one last question, what's the general process for a wage garnishment in Ohio?
Thank you. In order to do a wage garnishment in Ohio, one, you'd have to have a valid judgment that's not dormant. Two, you'd have to know who the employer is, and they would have to be a W-2 style employee and not a 1099 contractor. If those things are in alignment, then you would issue what's called a Note C in Ohio, which is the initial notice to the judgment debtor that their wages are going to be garnished. They have a certain statutory period of time to answer that. I believe it's 21 or 14 days. and they can mail you the money that you would have garnished otherwise, as long as they send you your paycheck, so that you can audit to make sure they're sending you enough. If they do not answer the Note C, then the next step is to file the formal wage attachment paperwork with the court. Then the clerk of courts will issue it to the employer, and then they'll start to track everything. There are certain notices about tracking the balance. The employer will send the money to the court will retain poundage and then release the rest to the creditor, and records are kept of all these financial transactions.
And one more, and then we're all done with you, I think. What's a creditor's bill, and what's the difference between a creditor's bill and a wage garnishment?
Thank you, I appreciate that. And I would like to tell you that they act similarly in some ways. If you have a 1099 person working somewhere, an independent contractor, you could attach their wages through a creditor's bill and not a wage attachment, because they're not an employee of that entity or the person. A creditor's bill is an effort to take what somebody has coming to them that is your judgment defendant. So think of a triangle. You're in one corner, the asset that you're trying to attach is in another corner, your judgment defendant in the third corner. You're trying to intercept what was to be paid to them through a creditor's bill. You have that statutory right in Ohio to attach money coming off of a contract, money to be paid over time, anything that is intangible in nature that is attachable. The statute delineates those causes of action, things of that nature. For example, if you have a judgment defendant who is in a car crash and you know they have a personal injury case going, you could file a creditor's bill to attach those proceeds from the personal injury case. It's just a slim example. I'm always available for any questions, online or offline, and appreciate the questions that came in today.
Thanks, Don. Our next speaker is going to be Roy Schechter, who's got over 20 years of experience doing employment law, and he's going to talk about how to avoid workplace lawsuits.
Got to unmute yourself. Yes, good morning, everybody. Thank you so much for attending. We couldn't have a party if nobody came, and we thank you so much for your time and attention. I'm going to discuss briefly here and hitting the high notes of how to avoid workplace lawsuits, how to prepare for them, and how to make sure that the process goes as smoothly as possible if you find yourself in the unenviable position of having to deal with one. I've been a senior litigation attorney here at Weltman Weinberg for about 5 years, and before that I had my own firm in downtown Cleveland doing all manner of complex civil litigation in state and federal courts, and before that I was a Cuyahoga County prosecuting attorney. But including the types of matters that I'm involved with generally involve business disputes, contracts, construction, professional liability, and related matters, but I also have a wealth of experience representing clients in employment-related matters and representing them in front of unemployment commissions, civil rights commissions, and in courts and arbitration forums. I also advise clients on human relations matters and employment matters, and do workplace investigations where that's appropriate. And if any of you have these kinds of questions, I encourage you to reach out to me, often before the problem arises, as one of the best ways to avoid suits is not to do the things that get you sued in the first place, or to be prepared for dealing with them when you get that feeling that you're going to have to handle a workplace complaint, often filed by a current or former employee. So if you call your attorney, get some input, get some advice, we can help prepare you to deal with that either before, after, or during. And as you might understand, one of the significant sources of workplace lawsuits is, and wait for it, your own employees. These can take the form of disputes and issues surrounding hiring, termination, compensation, discrimination, sexual and other harassment, discrimination, and hostile work environments. And even if you think there's little merit to these cases, they can be expensive and time-consuming to litigate. And if the facts are bad and a jury believes them, can result in significant money damages and significant attorney fees along the ways. A lot of employers don't know that you can actually obtain insurance for these kinds of suits. That was not common many years ago, but now it's not that unusual. So for companies that hire and fire a lot of employees, it's often a good investment to find out whether your business liability insurance policy provides any coverage for workplace related lawsuits. These can be discrimination, harassment lawsuits. And if you have that coverage, you'd know that the most you're going to be on the hook for is your deductible. And if you have that kind of insurance, the insurance company pays for the defense, which is your attorney fees, which can be substantial, and what they call indemnification is any kind of liability that might arise from this particular lawsuit, and that includes the paying to settle a lawsuit if it's determined that that's an appropriate course of action. Also, if you're terminating someone that you think could create a problem, someone that's raised issues about discrimination or not thinking they were treated fairly, or in the case of high paid employees, it's worth it to consider offering them a severance agreement. And I prepare lots of severance agreements. They're not required. Some people, and usually employees, think that if they're terminated, they're required to get some kind of severance, but that's not the law. They're not required, but if they're offered, they can include settlement provisions where the party receiving compensation agrees not to sue you. And that's for just about any kind of claim you could include in there. And those are enforceable in Ohio. So it's good to consider when you're terminating someone, whether you want to offer them some kind of severance agreement, and it can give you a little peace of mind after the termination. It's also important to remember the concept of employment at will. And I think most people have heard that concept. But basically, simply stated, it just means that either side, the employer or the employee, can terminate the employment relationship at any time, for any reason, or for no reason at all. You just can't terminate for an illegal reason. And those illegal reasons are the ones you would think of are the discriminatory basis that there are statutes prohibiting termination for age, sex, national origin, disability, religion, and things of that nature. So just remember, you don't need to give someone a reason that they're being terminated. And often I think the best way to go about that is to just say that you come to a point where you're going to go in a different direction, that you think it's a good time for them and for you to terminate the employment relationship. We appreciate all the fine work you've done, and your last day will be, whatever the last day will be, and often it's today. But remember, the more you say can and will be used against you in a court of law. As some employers think that you need to have a basis for termination, they often come up with things that might not be completely accurate, or they don't want to tell somebody the real reason that they're being terminated. And that's not a good idea, because then if a good plaintiff's employment lawyer looks at the situation and can prove that the termination was not for the reason given, mind you, you didn't need to give a reason, it makes it look like the termination was pretextual and that you're covering up some other illegal reason to fire, and that can give rise to a wrongful termination claim and make it more difficult to have a wrongful termination claim dismissed during the suit by way of summary judgment or otherwise. So just keep it short and sweet, and I think that's usually the best way to go. If you're sued for discrimination, you have the opportunity to prove that the basis for termination wasn't for any kind of illegal reason, that there was really a non-discriminatory basis for the termination. And that defense starts by preparing during the employment situation. This includes keeping good records regarding the individual employees, documenting issues, problems, complaints, workplace issues raised against them by other workers, documenting 90-day employment plans, coaching, and raising with them problems that occurred during the employment context. So if they're terminated later, you can say, hey, look what happened. This is why, these are the issues that we confronted during their employment. And they were terminated for these kinds of reasons, not any kind of discriminatory act that happened subsequently. In order to protect yourself, you also need to have published policies regarding no discrimination, no harassment, and distribute them. Make sure that the employee knows about them, signs for them, put them in a handbook, have them revisit them every year. At our firm, we're all asked to review all of our policies every year and sign electronically that we understand and will abide by them. And those can be very important if you're ever sued for discrimination, because a person who thinks they've been discriminated against, sexually harassed, victim of a hostile work environment, is required to give you notice of the problem that they're encountering or the things that they think they're being subjected to. And in order to do that, there needs to be a way for them to report it. And so you need to set up channels to report these types of issues for employees, make it easy for them to raise these kinds of issues, and document any kinds of complaints that you get. If you get a complaint, you're going to want to investigate, interview, keep good records. But after the victim gives you notice, you can't ignore the notice that you've been provided, or you will lose a defense that you have. And one of the defenses that you have is that upon first notice, you took prompt and appropriate remedial action to address the situations of sexual harassment, hostile work environment, or discrimination. And doing this in a prompt way sets up your best line of defense and can help you get the case dismissed if it's ever filed on a motion for summary judgment during the case before trial. So you need to take prompt and appropriate remedial action when you're notified. You should separate any alleged harasser and the victim. You can change hours. You can do things to accommodate a workplace investigation. As I mentioned, I'm often involved in these types of workplace investigations that can help get to the bottom of things and determine whether there is a problem. Sometimes there are problems that the management level people don't know about below. And if you find those kinds of problems, you need to take prompt action. If there's an employee that might be acting inappropriately, you need to make sure that that's going to stop. And with respect to the person that is registering the complaint, you don't want to demote them, fire them, take negative job action against the person that is reporting it, because that increases the likelihood that you're going to get sued. You want to let that person know what you're doing, the actions that you're taking this seriously, and do things to minimize or eliminate their exposure to whatever the situation is that's giving rise to their complaint. One thing in this day and age, you shouldn't need to be reminded of it, but I think we all should consider it. Always presume you're being recorded. When people come in and talk to you, when employees are raising issues with you, anyone with a cell phone can be recording the conversation. And if they raise a complaint and you're not taking it seriously, and this is something that's a subject of a recording, that's not good evidence for you should the matter ever proceed to some kind of lawsuit. And one thing that we all have to avoid against is allowing a hostile work environment to exist. What is a hostile work environment? It's kind of like one of those I know it when I see it situations. It's whatever a reasonable person would think interferes with somebody's ability to do their job. It can be a sliding scale. And juries don't like evidence that inappropriate things were tolerated in the workplace. So you want to have policies included in your policies. You want to emphasize that you don't permit off-color jokes, pictures, emails, racist matters, sexual innuendo. Even these days, jokes and statements about political parties and strongly held political beliefs can give rise to some people saying this is a hostile work environment. So you want to do everything you can to know your employees are going to not be subjected to these things, and that you as management are doing everything you can to eradicate that. And if it's brought to your attention that there are things going on that are inappropriate, that you take the kind of prompt and appropriate action to make them stop. Not that it ever was appropriate, but the old, it's just a joke, or boys will be boys, or you should have thicker skin, doesn't cut it these days. And it's not the kind of thing that you want to be having to present to a jury if a matter ever goes to all the way to trial. And so in order to protect yourself, you want to make sure that you're documenting all complaints, discipline issues, emails, and a sub-file for that employee so you can have it ready at hand whenever these issues might be raised. You want to do good and substantive regular reviews that note the good and the bad. You want to let the person know what they're doing that's good and positive and helpful in the organization. You also want to let them know and put in those reviews if there are issues that have been raised, if there's things that need improvement, because those can often be good evidence for you should you have to negate claims that there was some kind of discrimination or hostile work environment, and that the reasons you made for termination were pretextual or made up after the fact. If you get demand letters from attorneys from ex or current employees, don't ignore them. It's important that you respond appropriately and promptly, and I'm happy to help you discuss these issues and to help craft an appropriate response. A lot of times you can let the attorney contacting you know that the facts aren't exactly what they thought they were, and that what they may have been told by the employee is not everything there is, and that can be very helpful and even can help avoid lawsuits. And if it turns out that you have insurance for these kinds of claims, if you're threatened or sued, you give prompt notice of it to your insurance company, because giving prompt notice is one of the requirements under your policy of insurance to give rise to their duty to defend and indemnify you. And if no insurance, it's important to involve experienced employment counsel from the outset. And as soon as these issues come up, it's good to talk to somebody. Or if you anticipate that these issues might come up, you're terminating someone that you think has been a problem, it's good to speak to an attorney in advance, and maybe you can come up with strategies to avoid it becoming a much more unpleasant situation. And I'm always happy to speak with clients about that and help them navigate the waters here of the termination process. And as I said, there are instances where workplace investigations are necessary and helpful, and I'm also happy to discuss those with you. And,
Thank you so much, Roy. That's there's a lot of detail inside of employment issues, and something we all have in common. Our final speaker today is going to be Stefanie Kempfer Collier. While we say we're the Cleveland local office, we're lucky enough to have Steph with us remotely from Indianapolis, Indiana. Stephanie's going to talk about the eviction process and what's going on in our post-pandemic world.
Hi, good morning, everyone. Thank you, Amy. They said save the best for last, right? I'm just kidding. But anyways, I'm Stefanie Collier. I've been with the firm for almost 7 years now. Part of my practice area is handling landlord and tenant issues. So whether you are a property manager, a landowner, or even a credit union or bank who has foreclosed on a property and found that there is a prior owner or a tenant still in possession of your property, you may have had to engage in the eviction process at some point. So we're going to talk about the eviction process in Ohio this morning. So the first step is always determining whether your tenant's in default. The most common type of default that we see is non-payment of rent. Your tenant just simply stops paying you rent. But there are other types of default out there. The most other common types of default that we see are drugs in the unit. You suddenly have knowledge that there's drugs, or maybe the DEA raids your unit. We've had numerous phone calls with those types of situations, or perhaps there's a pet in violation of your lease agreement. Those are all types of defaults. The Ohio Revised Code also gives us tenant obligation defaults. Breach of peace is a common type of default that we might see. So once you've determined your tenant is in default, and we determine what type of default it is, you're going to have to serve an appropriate notice under the Ohio Revised Code to your tenant. So let's say it's a non-payment situation. So then you're going to serve what's called a 3-day notice on your tenant. The 3-day notice is statutorily required. There is certain language that must be inside that notice. The Ohio Revised Code gives us that language. There's we call it the warning language, and it must be conspicuous. So what does that mean? So it means that language needs to be bolded. It needs to be big lettered. I like to put a big box around it. That way it is very obvious to your tenant that you want them to leave. And the other notice that we might see is what we call a 30-day notice to terminate. So depending again on the type of default, let's say your tenant likes to play really loud music. That we would consider a breach of the peace. And under Ohio law, you would have to first serve a 30-day notice to essentially terminate that type of behavior. If your tenant continues playing that loud music, we're going to give them a 3-day notice after the 30-day notice expires, and then proceed ahead with our eviction. So how do you serve those notices? Ohio law also gives us ways to serve it. Typically, we're going to either hand deliver it to our tenant, we're going to leave it at the premises, or we can serve it via certified mail return receipt requested. In calculating the 3 days, it's 3 whole business days, not counting the date of service or holidays or weekends. So let's say I go and serve a 3-day notice today. So tomorrow, Friday, we would consider the first day, and then Monday and Tuesday would be the second and third days. So the quickest we could file that eviction would be on Wednesday. That would be after, if your tenant does not either pay or do whatever you have put into your notice to cure that default. And we could proceed ahead with the eviction. Accepting rent after serving the 3 days. So if you serve a 3-day notice for non-payment of rent, and then suddenly your tenant shows up, maybe with partial rent or either the full rent, is typically, if you accept that rent, it's going to be a waiver of that 3-day. So what I typically recommend to clients is to give your tenant a written notice that we are going to hold on to that rent until we have a court date, and let the court decide how we are to proceed. Unless your tenant obviously tenders full rent, then we can go ahead and just not proceed ahead with the eviction. But it's really important that if your tenant does give you partial rent, that we are giving them notice ahead of time, especially written notice. That way we can bring it to the hearing so your tenant's aware that we're not waiving that 3-day notice. So once we've given the notice and the cure periods have expired, we can go ahead and start preparing the eviction complaint. What I would need from our clients is always the lease agreement if you have one, ledger, your 3-day or your 30-day notice, or both if you had to serve both. And then if you are in Cleveland proper, there are 2 other requirements. One is actually relatively new. It's the lead-based certification program that rolled out last year. So depending on where your property is located within the city of Cleveland, the city rolled out based on different zip codes, whether you need to be lead-based certified or not. So we would have to attach an affidavit, and if your property has come up for the lead-based certification, you either need to have your application in, your certification already approved, or if your property was built after 1978, then it's exempt. So the other requirement is to make sure you have a current rental registration on file with the city of Cleveland. Akron also has a rental registration program, and the city of Toledo does as well. So making sure that you're in compliance and have your updated rental registration is really important, because the courts will not grant evictions unless we have a current rental registration on file. So once I have all that documentation, we can go ahead and file the eviction complaint. Most courts will take set hearings anywhere from about 3 to 5 weeks out. At the hearing, I will need the person who served the 3-day notice to appear and testify as to how that notice was served, and that either no rent was accepted afterwards, or what the default was, and the reasons for the default, and then the lease terms as well. If the court grants the eviction, the court will go ahead and issue what's known as a writ of restitution, and that writ will give you, essentially gives you restitution of the premises, gives you the premises back. The writ gets served onto the tenant, and then a move-out date is set. If the tenant does not move out by that move-out date, then we can request the court bailiffs to come out and assist us with the move-out. Every court deals with move-outs a little differently. Some courts require you to have a moving company at the bailiff set move-out, or locksmiths to change the locks. So that'll just be determined per whichever court we are in. So after the move-out, after your tenant moves out, I always recommend clients go through the property very thoroughly, take lots of photos of your damages, because we want to make sure that we preserve all the damages, so we can go after money damages after the move out. So calculate your unpaid rent, any late fees, damages beyond normal wear and tear to your unit, If you had to hire a moving company, the courts will typically allow those charges to be added on as well. So all of that will get added up. We will subtract out the security deposit and then move forward with a money damages complaint. So if you have any questions, please feel free to contact me. I'd be happy to answer them.
Hi, we do have a few questions, but I'm also going to open it up since we're nearing the end of our time. If any of our listeners or people want to ask some questions, please feel free to do so through that question submission button on the control panel as you're looking. And I did have a couple come in. One is for Scott Weltman, who talked about breach of contract. Is there any documentation that a client can provide when they're sending you a new matter that's going to ultimately help you in collecting the judgment?
Yeah, thank you, Amy. Thanks for the question. What I can tell you is the best source of information for us to ultimately get you money is the client. And so, just simple, let's say someone's been paying you over time and then they stop paying. If you can get a copy of a canceled check or the bank account information, obviously, to pick up on what Don said, if we know that information once we get the judgment, the sooner we have it, the better. We're not clairvoyant, we don't read minds. As much demographic information you can get us about your defendant, whether it's a business or a person, and if you can get it to us up front, we need that knowledge so that we start developing a strategy early on what we're going to do when we get our judgment. If you get a judgment against a judgment-proof entity or person, it doesn't do us any good. And so, yeah, any asset information it may have nothing to do with your cause of action for why you're owed money, that's going to help us. And the sooner you can get it to us, the better. Thank you.
Thank you, Scott. We have one for Dan Friedlander. Dan, you mentioned a lot about the timeliness of making sure you notify your insurance company and do a litigation hold. How long do you get to respond to a counterclaim generally?
The actual amount of time to respond to the counterclaim in
That's
Ohio would normally it'd be the same as the complaint. It would be 28 days to respond to the counterclaim. But as far as notifying the insurance company or someone like that, obviously you want to be able to do that as soon as you reasonably can. Most of the policies have language in them indicating words to the effect of as soon as practicable, you should let us know. So that needs to be a priority, and you don't want the insurance company to ever come back and say, well, gee, it took you 6 weeks to get to us on this. We're not going to allow coverage.
Thank you, Dan. And one last question for Steph. There's been a lot of talk about rental assistance during the pandemic. Is that rental assistance still available, and does it help landlords and tenants or just the tenants?
No, it helps both. It's absolutely still available. Usually legal aid will assist tenants with obtaining the rental assistance, but what it does is it'll pay back to rent and then typically a few months ahead as well, just depending on the situation. But yeah, absolutely still available. It's a great program.
And then I have one for Mr. Mausar. What factors do you think should be considered when you're deciding whether or not to take a settlement or go after a balance in full? Oh, did he log off? I think we lost Don. Maybe one of you can jump in.
All right, here we go. It's really a business. It's a business decision. Settlement to is money in the hand, and that's always a good thing. Time value of money should be considered, and it's a total business decision. Collection in full is always nice, but you have to take into account how long will it take you to get there, and how much in costs will it take.
Thank you. I want to thank, or we as a team really do want to thank everyone who came and participated today and asked questions. We hope you found our presentation informative and helpful. As a reminder, you're going to see a survey at the end of this webinar. We'd really like it if you filled it out and shared your feedback. It helps us make future webinars more relevant and more on point for your needs. Want to thank you for attending. You've seen the information for how to reach out to us, so if anything occurs to you later that you want to discuss, feel free to email or give us a call. And thank you again for attending. We hope you have a great summer.